The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Hi, everyone. Welcome to Short Circuit, your podcast on federal courts of appeals. I'm Anya Bidwal, filling in for John Ross, who is inexplicably sleeping in. This week, we have two amazing guests and three very important cases to discuss. Two of these cases concern the doctrine of qualified immunity, and the third one is about municipal liability. Scott Michelman is legal co-director of ACLU's DC affiliate. He is a very experienced litigator and a lecturer at Harvard Law School. Scott has argued before the U.S. Supreme Court and hopes to return there next term with an amazing qualified immunity case that he's going to discuss with us here today. Thank you for coming, Scott, and it's an honor to have you.
Thank you, Anya. I'm so happy to be here.
Adrian Sneed is a lawyer with Whiteford Taylor Preston. He comes to big law practice from a fascinating world of politics, having served as counsel and foreign policy advisor to U.S. Senator Jeff Markley of Oregon. His portfolio included criminal justice, national security, foreign affairs, privacy, and civil rights. Welcome, Adrian.
Thank you, Anya. It's a real pleasure to be here. I've been a longtime listener, and I really appreciate the show you all put on, and it's truly a pleasure and an honor to be here and be part of it.
Thank you so much. I paid him to say that. Let's start our discussion with Scott's case, Baxter versus Bracey. It's a Sixth Circuit case. Scott, could you please introduce it and also describe its current stage and your involvement with it?
Sure. So Alex Baxter was a homeless man who, after sleeping out several nights in a row in freezing temperatures one January in Nashville, was looking to break into some houses or find unlocked houses to steal electronics equipment that he could sell to try to get himself money for a hotel room. He was spotted doing this, and a large police presence arrived at the scene. He fled into the basement of a house, where he was cornered by two officers and a police dog. The dog was released to find him. It found him without attacking him, ran back and forth across the basement of the house, and was then corralled by one of the two officers. At this point, Mr. Baxter, having recognized that he was cornered, sat down and put his hands in the air, a well-recognized gesture of surrender. Nonetheless, the dog's handler, one of the two officers, then unleashed the dog again to attack Mr. Baxter. It latched onto him for anywhere between 30 seconds and 60 seconds, creating significant puncture wounds under his armpit because his hands were raised, and ultimately requiring emergency medical treatment. He then sued the officer who released the dog and the second officer for failing to intervene in the dog attack. And initially, particularly for a pro se litigant, was doing pretty well. He had qualified immunity denied at the district court level, appealed up to the Sixth Circuit, and the Sixth Circuit, the first time around, affirmed the denial of qualified immunity. It turns out the Sixth Circuit had previously held that the cops could not sick a dog on a man who was not threatening and who had surrendered.
So kind of a clearly established...
So the question, as you know, in qualified immunity is whether the law was clearly established. And prior to Baxter's dog attack, there was a case saying you can't sick a dog on a man who had surrendered. Now, the previous man, and I go into these details for reasons you'll see in a minute, the man in the previous case had been lying down on the ground when he surrendered. You'll remember that Baxter was sitting down on the ground
really big
with his hands up. It's a completely different case, according to the Sixth Circuit panel opinion that we're challenging. Now, the first time it went up to the Sixth Circuit, as I said, they affirmed the denial of qualified immunity. It goes back down. Baxter is still pro se. He gives a deposition corroborating everything in his complaint. It's a lengthy deposition. Actually, his story holds up under significant questioning from the city's attorneys. Once again, at summary judgment, qualified immunity is denied. Now the officers appeal again. It goes back to the Sixth Circuit, but a different panel, a different three-judge panel gets it this time, and they break with all of the other judges who have heard this case, and they say, you know what? Lying down and putting your hands up, those are two different things. So the fact that we had said it's not okay to sick a dog on a man who surrendered by lying down doesn't tell us what to do when a man has surrendered by sitting down with his hands up. Those are two different things. The law is not clearly established, and therefore Mr. Baxter loses.
Well, in the case, they actually say the reason we're not really disagreeing with the other panel. It's just a different stage of the litigation process, right? It's the summary judgment stage rather than motion to dismiss.
That's right. So one of the reasons the panel says, okay, we can disagree with our prior panel is it's a different stage. The problem for the second panel is they don't actually disagree about any of the facts. The facts are all the same. The district court found, and the panel did not reject that Baxter's testimony corroborated his complaint. So in the first panel opinion, they're hearing the facts presumed in favor of Mr. Baxter as alleged in his complaint. In the second, presumed in favor of Mr. Baxter as the non-movement on summary judgment. So essentially, you've got the same facts, a couple of additional details, but the general outline of the story remains the same. And ultimately, I think the key sentence from the opinion, and the one that I think epitomizes the problems with qualified immunity, is where the second panel says, even though they recognize that raising his hands might show he doesn't pose a threat, they say Baxter does not point us to any case law suggesting that raising his hands on its own is enough to put Harris on notice, the officer, that a canine apprehension was unlawful in these circumstances. In other words, says the second panel, you need a precise case with the same facts. We think that is a major problem in terms of not just existing qualified immunity law, but it shows the dysfunctionality of the doctrine of qualified immunity.
Doesn't the panel also mention a different case that involves a dog and sort of a law enforcement context?
It does. The panel likens Mr. Baxter's case to a different case, but that case involved a suspect who had not surrendered. So one would think that the case about the surrendering man would be more on point, but sort of endemic in this area of law is panels sort of picking and choosing what they think are the most analogous cases for this clearly established inquiry, and there's a lot of inconsistency in the doctrine, and that's what our panel that's what our petition shows, and that's why we think the Supreme Court needs to take a fresh look at this whole doctrine.
So I want to jump in. I find this discussion very interesting because when I read this case, I only read what the Sixth Circuit wrote. I had no idea he was sitting on the ground, and it sounded like from the way the opinion was written that this was a split-second decision, right? That was he really surrendering, or was he, about to surrender? Maybe he put his hands up at the moment or just before the officer released. And in fact, when I met with Anya prior to this, I said, this doesn't sound like a very sympathetic case. But hearing the fleshed out facts makes it sound very, very different. And I'm very curious, just thinking out loud here, why did the Sixth Circuit ignore all these very relevant and very detailed parts of this case that probably would have made a difference to most of the people reading it?
Well, I think it goes to the malleability of the qualified immunity standard. There's a lot of opportunities for strategic manipulation in the standard, and Professors Nielsen and Walker, for instance, have done a study suggesting that panels of all Republican-appointed judges versus panels of all Democratic-appointed judges approach these questions very differently. And so I think that is one of many problems with current qualified immunity doctrine, including that it is not based on the text of 1983. It is not faithful to the common law history that it supposedly implements. It obviously decreases the adherence to the rule of law because constitutional violations are immunized. And we've got this problem of inconsistent decisions and opportunities for manipulation.
So I'm very interested in one thing you say, because I noticed on the panel, not writing, is Judge Thapar. And Judge Thapar is very possibly going to be the next Republican choice for the Supreme Court. He was definitely high in the mix at the White House from my sources inside the White House before our friend from the D.C. Circuit, whose name shall not be spoken, was placed on the court. It's also very interesting. We'll get into it in my case, where my panel was very mixed with 2 Democrats and 1 Republican, and it still goes against the plaintiff. So very interesting.
I think it's really a question of judicial engagement versus judicial abdication, right? It's more perhaps than whether you have Republicans or Democrats on the panel. It's kind of, does a judge want to engage with the facts of the case and carefully consider them, or does the judge want to use qualified immunity as a very convenient doctrine to actually not have to deal with a case?
Certainly after Pearson versus Callahan, it's very easy for judges to brush cases aside and say, as the panel did here, we're not even going to tell you whether this is a constitutional violation.
Talk about
we're
this
just going to reject the claim based on immunity and not define the law going forward. So the Supreme Court has held about 10 years ago that the sequence of decision in qualified immunity can go any way that the lower courts want it to go. They can decide the constitutional question and then decide whether the right was clearly established, or they can simply decide there's no clearly established law here and we won't tell you what the Constitution says about this. The difficulty with situations in the latter scenario is that it doesn't establish the law for the future. So Justice Stevens once criticized the doctrine of qualified immunity as providing for essentially one free violation in a novel situation. But if the law is never established, it never becomes clearly established for the next case, and so there's no limit to the number of free violations that police officers can potentially have. What happens the next time a man raises his hands in surrender? Do they get to attack him there? Now, Mr. Baxter said in his deposition he's heard, word on the street in Nashville is the officers like to teach a lesson to fleeing suspects by roughing them up a little bit. That's exactly the type of situation where you want a clear constitutional rule that says, no, you can't do that. Once a suspect surrenders, that's the end of it. And even here, I mean, getting back to Adrian's point about the facts of the case, even reading the decision itself, obviously I provided more context, and you get more context out of the Sixth Circuit panel opinion. But even within the 4 corners of the decision itself, you get the fact that the dog was corralled by the officer. The Baxter had raised his hands in surrender. They don't mention that he was seated, but and 5 to 10 seconds elapsed. Think about how long that is. 1 Mississippi, 2 Mississippi, 3 Mississippi. There was a moment there where Officer Harris has the dog by the collar, Baxter has his hands in the air, and he waited, and he saw he wasn't moving. Then he releases the dog.
One of my first thoughts upon reading this case also, because when I was in the Senate, I did a lot of military policy, is if we were under the Geneva Conventions and this was a fleeing soldier who then decided to surrender, would it have been okay for the military, for some soldier to release a dog or even shoot the guy? No, it wouldn't. But yet, in the civilian context, you aren't protected. Where the court is saying this isn't a constitutional right.
Should this go to clearly established law?
Right. I mean, I think this is something that, I'm sorry, I haven't looked up the Geneva Convention, but my general understanding of military law and policy is you could not do this. This would not be part of the rules of engagement, and it would not be part of what we could do to an enemy combatant, let alone a civilian who is surrendering to police.
Right. And what I think this goes to, the sorts of results that are permissible under the doctrine of qualified immunity is that all types of constitutional violations go unredressed, go in the future undeterred, simply because nobody has done this precise thing before. And we see that too in the Georgia case we're going to talk about too, an outrageous set of facts where the court throws up its hand and say, well, this raises sort of complex issues about causation, et cetera. And we're, so we're not going to hold anybody liable. The other thing I think it's important to note is qualified immunity has come in for increasing criticism for all of the reasons that we've talked about: the results, the infidelity to history, the failure to develop constitutional law for the future, the lawlessness of it, and it's at a point where there is a growing cross-ideological coalition, and you see from the amicus briefs that were filed in our case, including by the Cato Institute and both liberal and conservative scholars, and the justices that have called for reconsideration of the doctrine. You have Justice Thomas on one side, who criticized it severely in a 2017 opinion, and you also have Justices Ginsburg and Sotomayor, who criticized it quite sharply in 2018. So I think the time might be ripe for a new look at this doctrine.
Let's then, since you're mentioning Supreme Court justices, talk a little bit about Justice Gorsuch and his opinion in Browder when he was on the 10th Circuit of Appeals, right? In Browder, it's a case also involving excessive use of force. And Justice Gorsuch basically says, well, shouldn't you just go to state court and bring a common law cause of action, right? He says, I understand when the common law's door is shut, then you come in under 1983, and I'm more than happy to consider it. But our state law courts are very flexible. They have very flexible doctrines, and they could accommodate those kind of claims. So why not go to state courts? Why go to federal courts instead?
Well, there are a number of reasons. One is, if you go back to Monroe v. Pape, the case establishing that 1983 provided this alternative forum in federal court for most constitutional torts, the court found that Congress was very concerned that there be free, unfettered access to federal courts. There was a concern that state courts might not be as sympathetic, that the remedies might not be robust, or that various state policies or defenses, statutes of limitations, notice of claim requirements might bar claims that could nonetheless proceed under Section 1983. So there are both procedural and substantive disadvantages to going into state court. And it's interesting you mentioned Justice Gorsuch, because I was encouraged in a number of his opinions just this term how concerned he was for upholding constitutional requirements, for sort of basic ideals of liberty, and fidelity to history. Now, those are themes that fit very well with our attack on qualified immunity, which is all about making sure basic constitutional rights are upheld and being more faithful to an original understanding of official liability that did not give the kind of broad immunity we're seeing applied today.
Excellent. We're going to keep an eye on your cert petition. So the conference is on October 1st, right?
October 1st.
All right. Fingers crossed. Adrian, now let's go to you and let's talk a little bit about Corbett versus Vickers, the 11th Circuit case.
Well, Anya, thanks for giving me the case that would make me so upset I forgot to brush my teeth the other night. And my partner told me that if I kept talking about this case, she was going to lock me out of the bedroom. The facts here are just egregious from a plain reading. And I'm actually going to read you the facts as the dissent wrote them, because there's really no difference between what the majority said and what the dissent said vis-a-vis the facts. And part of that is because we're at the 12b6 stage. We're at a motion to dismiss stage. So all the court has is the pleading. So Corbett, importantly, is the mother of the minor who's only identified as SDC, and Vickers is a deputy sheriff of Coffee County, Georgia. On July 10th, 2014, several officers, including Deputy Sheriff Michael Vickers, initiated a search to locate and apprehend a criminal suspect, Chris Barnett. The search led them to Amy Corbett's property after Barnett, who the plaintiffs had never met, wandered into the area. Barnett, Damon Stewart, and 6 children, including Corbett's 10-year-old child, SDC, and 2 children under the age of 3, were on the property's front yard. I assume they were playing. The officers detained Barnett and ordered everyone to get on the ground. An unidentified officer handcuffed Stewart. This is not the suspect. This is just some guy that was there, and held a gun against his back. The detained children were also held at gunpoint, each having an officer forcefully shove the barrel of a loaded gun into their back. So we're talking at least 7 officers here. While Barnett, Damon, and the children were detained on the lawn, Vickers spotted the Corbett family pet, a dog named Bruce. Bruce was being a dog. Although no one appeared to be threatened by Bruce's presence, Vickers attempted to shoot the dog. He missed, and Bruce retreated under the Corbett's residence. Roughly 10 seconds later, Bruce reemerged and was approaching his owners on the yard. Vickers fired another shot, again missing the dog. Unfortunately, the bullet struck SDC behind the knee as the child lay face down on the ground at the request of defendants. Importantly, SDC was readily viewable, a mere 18 inches from Vickers at the time the shot was fired, and the other minor children were within only a few feet of Vickers. As a result of the bullet wound, SDC suffered severe physical pain and mental trauma. Reading this, the only person in this whole area that is a threat to public safety is Officer Vickers. As a guy from Texas who grew up shooting, if this guy can't hit something that's around 2 feet away, I don't know how he ever became a police officer, and I don't know how the court could ever find that this was legitimate.
So why did the court find that it was legitimate?
So the court did hold that there was a constitutional violation, that 10-year-old SDC was detained for the Fourth Amendment purposes. That being said, the majority kind of hid the line here, but it essentially said SDC was an innocent bystander. Yes, he was yes, the child was detained, but there is no prohibition on police accidentally shooting somebody. If the police are shooting at a suspect and you accidentally get hit, well, that's just too bad. You have no rights against the officer, and qualified immunity stands. The dissent in this case, I think, got it right in a very short and very poignant and very pointed opinion, basically saying the officer had no right to shoot. There was no threat here. There should have never been a gunshot at all, and the officer is liable for that. And so, some other interesting points about this case, again, as we were talking about, this cuts across ideology. You had a Carter-era judge writing this opinion with a Trump appointee, and you had a Clinton appointee dissenting. So you have 2 Democrats and 1 Republican on this panel. You have the majority spending 34, 35 pages doing real intellectual jujitsu to show how somehow, although you don't have to have an exact factual parallel, there is nothing saying you can't just randomly shoot. An officer can't just randomly shoot at things, and if they accidentally hit people, well, too bad.
I was kind of pleasantly surprised, though, with their description of kind of clearly established law and the 3 buckets in which clearly established law fits in, right? Often we just think that what judges are looking for is the precedent directly on point. And Baxter versus Bracey is a good example of this, right? Where they really seem to be looking for something that, laying down versus sitting down, 2 very different things. But in this case, the court at least maybe its decision was came out wrongly, some would argue, but at least the presentation of the clearly established test seemed to be rather generous.
Well, I think that's right. I think it's important to recognize that the Supreme Court has allowed several different ways to meet the clearly established standard. Now, sometimes, as you say exactly rightly, Anya, the lower courts don't remember all of them, that there can be not only precedent on point, there can be precedent that is not directly the same, but that gives fair warning in a novel situation. And finally, as the majority also rightly says, there can be a case that is so obvious that no reasonable officer would have thought his conduct was lawful just based on general principles alone. And that's actually the tack the dissent takes here, that this was so obvious. There was no reason to shoot at the dog. The dog was unthreatening. So the fact that he missed, I think it would have been a cleaner case, and the majority wouldn't have been able to do so much jujitsu if there hadn't been accidental shooting. It would have been a cleaner case if he'd hit the dog, and there would have been a claim based on excessive force against the dog. It's ironic that the fact that he missed enables this whole long discussion, the jujitsu around whether accidental shootings have really been covered by the Fourth Amendment. But it doesn't seem like he should get any credit for having missed a dog he wasn't allowed to shoot and hit a kid he also wasn't allowed to shoot. So it's like additional wrinkles and additional wrongness have complicated the picture just enough for the majority that they could say not clearly established. It's the obviousness exception to all that that's supposed to cut through it and say, no, this guy was way out of bounds. Anyone would have known that.
Well, I think it's interesting because for me, that's where the majority's opinion breaks down. The majority likens this case and analyzes this case with cases where police were in hot pursuit and they shot at a suspect and maybe hit somebody sitting with the suspect or somebody very close by. In one of the cases the court uses, it says, you have a fleeing suspect with a hostage. Police officers shoot at the suspect and accidentally hit the hostage. Right here, we have a very different situation. We have, by all accounts, a non-threatening situation. And the fact is, we really don't know because the court is dismissing this based on the complaint at the motion to dismiss stage, which is itself inappropriate. The court is really it's supposed to take every inference for the plaintiff, and instead it's taking every inference for the officers, which itself is a very strange way to approach a 12b6 motion, a motion to dismiss. But beyond that, here, would it be excessive force, as you just said, to shoot a dog? Well, I think so. If a dog is not threatening anybody, most states and most jurisdictions have animal cruelty standards, and those are well-defined, reasonable. You can't just go out and shoot an animal. If you do, you're going to jail and you're probably getting fined. But yet here an officer shoots and misses twice. Again, was the officer drunk? I mean, what was going on if he's missing a dog that's a few feet away and hits a child that's 18 inches away? I mean, he's essentially standing above the child. And
should those state laws that you mentioned or codes, should that go to the test of clearly established and what it means for a law to be clearly established?
Well, that's interesting. And what the majority says here, which is really troubling to me, is it says the standards set by Graham, a Supreme Court case, inevitably lead that every reasonable officer in defendant's position to conclude the force was unlawful. If you have clearly established law saying you can't randomly shoot a dog, I'd say every reasonable officer should know that as an officer of the law. And yes, I think that should go into the analysis.
A particularly troubling aspect of the reasoning to me was the notion, and Adrian, you mentioned the Graham standard, the notion that bright lines are necessary to clearly establish the law. The majority says several times that the law is unlikely to be clearly established unless there are bright lines for the officer's conduct. If that's really true, if they're taking that seriously, that means the majority of Fourth Amendment claims, which depend on reasonableness, whether in the excessive force context or in the search and seizure context, you just have these standards that have to be applied and developed in case by case basis, and will rarely admit of bright lines. So there, even though they rightly recognize there are several different paths to get around qualified immunity, very narrow, winding, difficult paths, they then throw in this bright line requirement for clearly established law that makes it very difficult to imagine that constitutional standards as opposed to bright line rules could ever be clearly established in an individual case.
That's an excellent point. Do you think this is a potential vehicle for a cert petition?
I actually, when I first read the case, I did think about that. One difficulty might be that there does appear to be some confusion around the issue of accidental shootings that could complicate the case as a vehicle for qualified immunity reform. I think it doesn't actually help the majority because they're wrong to think of this as an accidental shooting. As Adrian points out, it's not that they had a legitimate. It's not that it was a legitimate shooting that accidentally hit the wrong target. It was an illegitimate shooting that accidentally hit the wrong target, which was also illegitimate. So to me, the accidental part was actually a red herring logically, but that creates enough complexity in the analysis that might make it a difficult vehicle. That said, I wouldn't be sad to see someone bring a cert petition on this case. I think it's helpful to have the Supreme Court see if they don't grant my case, they need to grant one of these cases. And it's helpful for them to see in petition after petition what the consequences of this doctrine are. I think for years, litigators were probably scared to bring these qualified immunity appeals from the plaintiff's side because the Supreme Court has been so aggressive in summarily reversing denials of qualified immunity. They've been so officer protective, but I think that may be in part because they weren't thinking about reconsideration. They were just thinking about, was the standard properly applied? And some of the applications of qualified immunity that they reversed may have been marginal by the district courts. Now we need to show them there's some really bad applications that disadvantage plaintiffs and underprotect constitutional rights. We need to show them that's going on.
In an ideal world, Scott, what would you like the U.S. Supreme Court say about qualified immunity?
In an ideal world, they would abolish it. In an ideal world, they would say this is not part of the text of Section 1983. This is not the historical understanding either of officer liability at the founding or of officer liability under Section 1983. And in fact, an early Section 1983 case, Myers versus Anderson from 1915, rejected something like a qualified immunity defense, albeit in a somewhat brief manner. The court basically made this up in 1967. It was the Warren Court, ironically, probably because they had expanded a lot of constitutional rights and they were a little worried maybe we're going pretty far, pretty fast. And in the case they actually did it, the officer had been held liable for failing to predict the future course of constitutional law. That's a very sympathetic case for the officer. But that principle, as it has been applied and changed and amended and metastasized, it's just gotten out of control, and it's led to out of control law enforcement. So I think the doctrine should be abolished entirely. And because, as we know from recent scholarly studies by people like Joanna Schwartz of UCLA,
friend of IJ,
this would not have a horrible effect on officers. More than 99% of officers are indemnified. That is, their damages are paid by their employing government. We're not opening the world up for officers to face massive judgments. Instead, we are opening up the possibility of accountability, compensation, and deterrence, where the judgments in the end get paid by governments that can afford them.
And I want to talk a little bit more about the majority's reasoning here, because we keep saying the dog was non-threatening, there was no reason to shoot. The majority takes issue with that. They say, well, that's a conclusory statement, and we disregard conclusory statements. So the majority is not saying the dog wasn't threatening. It just refuses to accept the plain language of the pleading, which generally it has to at this stage. And so I would like this case to be litigated further, maybe en banc, maybe a cert petition. But practically, and I think these are private sector lawyers, if this was my case, well, this thing's going to go down. It's going to get dismissed. I'm going to refile my complaint. I'm going to change the facts of the complaint the best I can. And here we go again, right? This is not likely a dismissal with prejudice. It's going to be a dismissal without prejudice with leave to refile. You refile this complaint, we're at a new stage. So that complicates things a little bit. I think this is a phenomenal case to go up for all the reasons stated. And practically, it's a very sympathetic plaintiff. I do think the majority's reasoning is very wrong. But that being said, because we're at the motion to dismiss stage before before the facts have really been come out. There's been no depositions, no discovery. We don't know what the situation was with the officer. We don't know what the situation was with the child. Maybe the child, instead of just laying prone on the ground, as it said in plaintiffs, maybe the child was moving, trying to kick the dog or something. And so, the accidental shooting becomes still illegitimate, but at least there's more understanding. Maybe the officer was under the influence of something. We don't know. I mean, there are just so many unknowns here, and this is why cases should not be dismissed at the 12B6 stage, at the motion to dismiss stage, and why I think, again, on that point alone, the majority is wrong here.
So what you're saying then, qualified immunity defense at the very least should not be allowed to be invoked at the motion to dismiss stage?
I mean, that seems clearly established within the law, but what I'm saying is they didn't even follow the rules for motions to dismiss. Right?
And just to build on that, on Adrian's point about conclusory statements, as a matter of Iqbal pleading requirements, that's where this idea comes from, that you don't accept conclusory statements. It's one thing, as the Iqbal court held, to say we're not going to accept a conclusory statement about the motivations of people that the plaintiffs have never met, that high-level officials in Washington who are alleged to have some discriminatory motive that plaintiffs have to take a guess at. And that was what was at issue in Iqbal. But in this case, there's no mystery here. It's not unclear why the plaintiffs would have been able to say the dog was unthreatening. They were there. Ms. Corbett was there. And so for her to say the dog was unthreatening, that should be enough. It's not that the allegation cannot be conclusory in any way. In some sense, all allegations are conclusory at some level. You are just stating the facts as you know them. What it has to be, the key, I think, is plausibility. And it is incredibly plausible to say that Ms. Corbett was in a position to characterize the dog's threateningness or non-threateningness. And if you, the opposite rule, if you take the majority's approach to its logical conclusion here, that you can't accept conclusory allegations, complaints are going to be 100 pages long. And plaintiffs are going to have to say, well, the dog was unthreatening because, subpoint A. I was in a position to observe the dog. And subpoint B, the dog was of such and such a breed. And subpoint C, the dog was walking at such and such a speed. It's going to become a version of the code pleading that the rules of civil procedure were trying to get us away from. If this approach is taken seriously, that a complaint based on personal knowledge and perception is deemed to be implausible.
Right. As a private litigator who does have to think about budgets and what we do, and as somebody who litigates both plaintiff side and defense side, for my defense clients, for my corporate clients, I love this case for the very reasons he stated, because it's going to, one, mean that I'm going to win so many more 12B6 motions in the 11th Circuit, simply because most of what plaintiffs state are conclusory facts, right? On the plaintiff side, it's going to discourage me from taking cases, because now all of a sudden my burden up front to make sure I don't lose on 12B6, I'm not writing a complaint that states the facts essentially, that allows us to move forward, that puts everybody on notice, and then we can go and do discovery. No, now I have to do essentially discovery and substantial discovery before I write the complaint, without the ability to go to court and get a subpoena or issue discovery under the rules of civil procedure. And my complaints are going to be incredibly long, incredibly detailed, with sometimes facts that I may not know, but have to plead without certainty because of this rule. And then I'm opening myself up to Rule 11 sanctions, right?
So it seems like pleading standard would actually be contrary to what the pleading standards were designed to be to begin with.
Exactly. There's so much wrong with this opinion. It's very troubling.
On that note, and in the interest of time, let's move on to our last case, and it's a little different. It's involving municipal liability rather than the issue of qualified immunity. JKJ versus Polk County. I'm going to introduce this case because the Institute for Justice filed an amicus brief in the 7th Circuit asking the entire Seventh Circuit to rehear the case and overturn the panel's decision. So in JKJ versus Polk County, prison inmates sued a prison guard for sexually assaulting them in prison. The guard pled guilty to the crimes and is now serving a 30-year sentence. The jury, in a parallel civil action, awarded $4 million to the victims. The verdict was against both the prison guard and the municipality. There was some serious evidence against the municipality, including that several years prior, another prison guard made inappropriate sexual gestures toward different prison inmates. The guard got away with a written reprimand. That's all the municipality did. They had a written policy beforehand, but obviously it was insufficient to warn that guard not to do these things. After that incident in 2012, which was prior to what is at issue in this case, the municipality did not adjust its behavior by, for example, providing some training and some monitoring. What's really interesting about this Seventh Circuit opinion is that they are overturning a jury verdict. And it's a very high threshold to be able to overturn a jury verdict. And they kind of disregard that evidence about prior conduct. There is a dissent by Judge Scudder, and he says that, listen, this is simply not right. What's really persuasive to the majority is that the municipality had a policy on paper. And the policy on paper said we prohibit sexual assault and we prohibit any kind of sexual, behavior between inmates, between prison guards and such. And they basically say that is good enough for us to avoid liability. And Judge Scudder in his dissent says that policies cannot exist on paper alone. And he says that failure to adequately train and monitor equals deliberate indifference, and therefore verdict against municipality should have been upheld. In our amicus brief, we essentially warn that it does create kind of a perverse incentive for municipalities where you can just have a paper policy saying we prohibit a certain conduct and then do nothing else. And that still allows municipality to get away with certain very outrageous conduct. So what do you think about this, Scott?
Well, I think this is one of many cases that illustrate the problems with the Supreme Court's municipal liability standards. Now, if you go back to where these municipal liability standards came from, they all trace back to the case of Monell versus New York Department of Social Services in 1978, where the Supreme Court first recognized that municipalities could be sued under Section 1983 for constitutional violations. But they threw in a caveat. They said the municipality could not be sued unless its policy or custom was the cause of the violation. Now, policy and custom are not words that appear in 1983. This was an atextual limitation that I think was most likely a compromise among competing factions of justices to get to the holding that municipal liability was available at all. But this caveat on municipal liability has proved incredibly difficult to define. It's created complex rules in the areas of failure to train, in terms of defining who is a final policymaker, whose actions can subject the municipality to liability, and ultimately led to a lot of municipal non-liability in cases like this, because the connection between the paper policy and the training and the unconstitutional result was not sufficiently strong for under the way the Supreme Court has applied this standard. 20 years ago in Bryan County versus Brown, Justice Breyer called for a reevaluation of the standards in this area, and I think this case is a good example of why he was right to say that.
For our listeners, could you explain a little bit more the kind of interplay between Section 1983 and municipal liability?
Sure. Originally, Section 1983 was not held to be applicable to municipalities. And in fact, the case that opened up 1983 as a vehicle to sue individual officers for constitutional violations, Monroe v. Pape in 1961, said in the same case that the municipality could not be sued. That was a case about police misconduct. They said sue the officers, but you can't sue the employing city, the city of Chicago in that case. That created a number of problems. One, that municipalities were essentially written out of the law of 1983, no matter how badly they behaved. And two, and of particular concern to the justices in the 1970s, 1983 was the vehicle through which desegregation orders were being imposed on municipalities, including school boards. If Section 1983 wasn't a vehicle to do that, what was the basis for those orders? And that the justices, recognizing the awkwardness of this result and the fact that municipalities weren't excluded anywhere from Section 1983, reevaluated the result in Monroe with respect to municipalities, and in Monell in 1978, as I said, opened up municipalities for liability. But they did so with this key caveat, this idea of a policy or custom, that respondeat superior, the normal vicarious tort liability rule that applies to every slip and fall, whether it's governmental or a corporation or the mom and pop corner grocer. If a 5-employee grocery store has a clerk who leaves a wet mop on the floor and a customer slips, is badly injured, and sues over it, that little store can be liable. That is the normal rule of tort law. It's called respondeat superior. It just means let the boss answer. And the Supreme Court says in Monell, yes, we're going to open up municipalities for liability, but we will not let them answer for every violation by their employees. Instead, we're going to require this greater level of causation that the violation stems from a municipal policy, that is an official policy, or a custom, that is a widespread practice. And the court has tied itself in knots trying to figure out what this is. They've said no respondeat superior, but most municipal violations don't come in the form of unlawful policies. Here, the jail said you can't rape inmates. Obviously, no jail has a contrary rule. There's no, we're not living in a society that would countenance a municipal policy of doing this. So the question is, are they taking seriously their responsibilities to enforce this policy, to train their officers on this policy, to supervise their officers on this policy? And that leads to very complicated questions of how many bad instances, how many violations does a plaintiff have to show before the municipality can be held liable. There was a tragic case that went before the Supreme Court several years ago called Connick versus Thompson, in which a man who was on the verge of execution was exonerated when it was discovered that there was exculpatory evidence withheld in his case by a prosecutor's office that had multiple violations of that type. And yet still the court said, no, that's not enough. This municipality hasn't engaged in quite enough of this specific type of misconduct that we're going to find them on the hook. It's a murky standard. It's difficult to apply, and it's also a strict standard that leaves a lot of municipalities without liability and a lot of plaintiffs without a remedy.
Should Monell then be replaced with the respondeat superior in a perfect world?
In a perfect world, it should. There's no basis to depart from the normal tort rule of respondeat superior. And throughout 1983 jurisprudence, the Supreme Court has repeatedly looked to tort law to define the scope of this statute. They often refer to 1983 as a source of, quote, constitutional torts. And so rules about causation, rules about damages, they all borrow from tort law. There's no reason that the basic fundamental principle of respondeat superior shouldn't apply. And again, if your mom and pop corner grocer has to be responsible for the bad actions of its employees, why can't the city of Chicago? Why can't the city of New York? be responsible for the constitutional violations of its employees.
So, I think something very interesting is that in that early case, I think that was an example of judicial engagement, right? 1983, I have the text in front of me. It actually does say customer usage. So that is in there. The word policy is not in there, but it makes sense reading it. But on the face of it, it doesn't necessarily establish a very plain reading of 1983. Does not necessarily establish municipal liability. I think it's appropriate to read into that, but I think that was an example of judicial engagement. And then but then the courts have tied themselves into knots trying to figure this out. And, this case is so interesting when I was reading it because there's obviously a differentiation of the facts, right? Are these facts enough? And in the majority's reading and the way they couch the facts, it's, a reasonable person can say, no, these facts weren't enough. This was a rogue person. There was policy, there was training. They did everything right, and you still had a rogue person. Well, it's absolutely true. Under respondeat superior, under any regular tort standard, it doesn't matter how much training you have, and it doesn't matter how many policies you have. You are still responsible for your employees' actions. We don't do that with the government, and it's a question of why, and it's a question of what are those policies. One of the most enlightening things I did in my law school career was take a police ride along. I just spent a whole day with a senior police officer who came and talked to our criminal law class. And it was so interesting to see from the officers' perspectives what they deal with on a day-to-day basis. And you can also see why if you put too many rules and an officer has to think too much at any one time, that can have a detrimental effect on public safety. That being said, this is a very different thing, right? Yes, you want officers of the state, and not just police officers, but that's anybody working for the government, to have some leeway to do their job in the way we ask them to do it. But they also have to be responsible for breaking the law and for harming people. And the fact that we don't seem to have a good system. Now, in this case, the person who raped the corrections officer went to jail. He was criminally prosecuted, and this is a civil prosecution. One thing I dealt with when I was in the U.S. Senate that I'm sure most of your listeners don't know about is there is a fund at the Department of Justice to reimburse victims of crime, the Crime Victims Fund. Well, Congress, in its genius, found that in the 90s and then 2000s, the Crime Victims Fund was growing by billions because of massive corporate liabilities. But they decided to use those billions instead of reimbursing crime victims to offset other spending. And they used it as an accounting tool. So for years, even though this account had $10, $12 billion in it, no more than $700 million, $800 million was going back to crime victims. That's been changed. When I was when I was working in Congress, we worked to change that. I think it's now up to triple that, so up to $2.1 billion annually. But the fact is, there's a lot of money to compensate people, and it's not being spent to compensate people. Instead, it's being spent to show that our deficits aren't quite as high as they really are. And, that's also a problem. I mean, we talk about the law, but there's a very practical side. And, we all deal with our clients. And our clients face a lot of issues, especially the ones that we sue on behalf of because of their situation, because of what's happened to them. And I think certainly the government owes it to people to have clear policies and law that prohibit their agents from harming people and hold them responsible when they do. And the government also has a responsibility to compensate people when their employees harm people. And here, again, the whole point of, I think, this podcast in this case is that the government and the courts have failed to protect people. They have failed to protect American citizens, even when Congress passes statutes that are meant to do that very thing. And I think this case, while it might be a close call, this went to the jury. Why isn't the jury? If this was a criminal case, there is no way the Seventh Circuit would have reversed. Right.
And before we go, that's one last thing that I want you, Scott, to address in terms of the issue of appellate review. Do you think it was prudent of the court to reverse a jury verdict?
Well, it's very hard to reverse a jury verdict, and it should be. And I think that's a good point the dissent makes in terms of the standard. To give a little credit to the majority, I think their point was less that they were disagreeing with the jury's finding of the facts, and more that they thought the court had permitted the issue to go to the jury on a misunderstanding of law. That is, too loose a standard for municipal liability. But that goes back, I think, to the more fundamental point that the municipal liability standards are simply too strict and are going to result very rarely in municipal liability, and therefore fail to give appropriate incentives for municipal leaders and managers to train and supervise their employees properly to ensure that everyone's constitutional rights are respected.
That's a perfect note to end on. Thank you both for being here, and we look forward to having you back.